Suzanne just sent a link to where you can find the handout, and you can find this recorded later on. You can find that in the chat box. So again, welcome. We'll just get started. So this is a series of 4 workshops. They'll last up to 2 hours. We always plan a 2-hour block, but most of them are getting done earlier than that. You're welcome to stay on and ask questions afterwards or during the session again. We already talked about a couple of different things. So today we're going to talk about wills, trusts, and ownership title, what it all means. Oops, now I got to go down here. All right. And I'm sorry, I should have changed the slide set. I put this in here earlier because Nathan and I were, but anyway, we've got Suzanne coming in for Nathan. Nathan's on a world trip today. So he's over in Europe today. So we got Suzanne graciously stepping in for us today. So we're going to again talk about these titles. What's it all mean for you? So here we got a gentleman walking through the wheat field, and he says, farms are not all the same. These materials may not directly apply to you, but there is a lot of information here that will give you some ideas. We've gone through the goals section. Again, we're going to focus on your goals as you go throughout this whole 4 sessions. But what do you want to accomplish with your transfer plan? That's what you want to think about as you're going forward with here, and you want to do that. So again, just take everything and just go forward. We talk about, even if you're not a farm, a lot of material still applies to you. So it's a very general, broad base. We're not accountants, we're not attorneys. We're just trying to give you some background information to help you with the process. So while your estate and transition goals are the foundation for your estate plan, understanding legal terms and tools can help you prepare for meeting with your professionals. Again, we'd like you to go out and have this background with workshops and listen to them, pay attention, do the goals worksheets, and then go see professionals because they're going to want to know what your goals are too before they can do anything for you. So you've got a whole bunch of people out there willing to help you, your accountants, your insurance agents for life insurance, your bankers, your lenders, your attorneys. A lot of people out there are going to help you get this done. But again, before you go see them, you want to make sure you've got your goals in mind, what you want them to accomplish for you. Okay. All right. So succession involves transferring the operation of business, not just assets. So you got to think about it's beyond just the assets, it's management, decision-making process, how to run the operation. Different parts of the farm have different things you have to think about. So again, think about the succession process. The transfer planning is an additional process beyond the estate planning where you're looking at your assets. How are you going to transfer those assets to the next generation? What's your goals in that process? And then the final thing we're going to talk about is transferring both the estate and involve legal process and proper pre-planning. So again, we've done these for 20 years now, and we've had many attorneys to sponsor this workshop, and they actually give discounts oftentimes if you attend the workshops because they know you're going to have your goals already worked out before you go to the sessions. We got some chats up here. So Suzanne is still sending those links out to you. So for the handout and for the recordings. All right. Right here. So we're going to talk about wills and trusts today and different titles of ownership. So wills are generally most associated with your estate plan. So a will is really a letter to the judge of what you want to happen with your assets. Everything you own can go on the will, down to your cup holders. Everything you have can be on that will. Who gets what? So there's no family fights after you die. They know who's going to get what. So it's most with your estate plan, and it works just fine. And we encourage you at least to have a will if you don't have. Betty has her hand raised, and so if you have a question, Betty, please put it in the chat box. And if you can't hear me, I can raise my volume a little bit. I can do that up a little bit in case I'm too soft. The last time I raised it, speakers in the front of my computer here, so how that might be what you would like. Does that sound better? All right.
Yes, you're a little bit clearer. Yes, that's great.
All right. Okay, so wills generally are very simple. You can set one up. We encourage you to, you can do it online. There are wills online examples. They're not all set up to be technically legal and defendable. So again, some people fight wills because it didn't have what they wanted in their plans. So we encourage you to use the legal teams out there to make sure you have a proper will. It's not going to be that expensive to get that set up, and it'll help you see that what you want to see happens. We're also going to talk about trusts. A trust may factor in your transfer and estate plan. Trusts can live beyond you. There's several trusts. We'll talk about the different types. But a trust can also, you can have revocable, irrevocable, and you can have control or not any control of assets. We'll talk more about that. And then the third one is ownership, titling, and business entities. Associated with a transfer plan, we'll talk about how you titles control how the things get transferred as well. So what is a will? Well, again, a will is a legal document that includes your personal representatives for your state. You can have multiple representatives if you want. At least one person is listed for the representative. It's instructions to the attorney and your representative and the courts to see how you want your assets distributed after you die. And so it's really a good document that you can, like I said, be really detailed or just general. You can get the big assets in there and then fight over the little assets. It's all up to you how you want to do it, but at least it'll start the process. We encourage all people of all ages to have a will, because when you're a young parent, you don't even think about it. You know, you're not I don't need a will. I'm going to live for a long time. And we've had in these workshops, I had a 6-week-old attend the workshop with their parents. Well, what about that child? If mom and dad get an accident today, we don't want that to happen, but if it happens, what's going to happen to that child? So you want to think about that. Who's going to be the guardian for that? Who's going to have the financial bearing of your assets for them protection for the future? So there's a lot of things to think about you can do in a will to protect your minors before they become adults. Okay, so that's something to think about when you set up a will. The function of a will is to carry out your wishes for your estate upon your death. You can leave property to someone who would not inherit under state's intestacy laws. So, you know, the will has spouse and then kids, and how it's divided, that'll take care of it. Minnesota has a will to divide your assets if you don't have a will or any kind of estate planning. They'll do it. But if you do a will, you can say you had a nephew or say you had a hired hand that really was your hired hand for life, and you think he deserves something or she, well, you can do that in the will. Okay, you can designate that. If you don't have the will, the state's not going to give that hired hand anything because they're not bloodline. Okay, so you want to make sure if you want to do that, you can do that. It also prevents a person who would inherit under the state's laws. So say you had somebody you really don't want to have inherited, you've wrote them off. I mean, unfortunately, our families don't all get along like smiley, gentle people, and sometimes we have family battles and alienate each other and don't talk. We don't want that to happen, but it does happen sometimes. In your will, you can say who you're gonna black sheep or whatever, leave them out. Okay, you can leave the property to your heirs in unequal shares. With farmers, that's really a big issue because a lot of us talk about our land base, and that's a huge asset. With our land prices the way they are today, your balance sheets, here's land, here's everything else. So if you want to maintain the farm, you can divide it equally as long as you think all your kids get along good. And you can, if you have a trust, you can even tell them they have to rent to the farming heirs. Different things, there's rules about that with a trust. With a will, it's not death. It's at instructions after death. It might not continue on. So if you leave it 4 ways or 5 ways or 2 ways, it can cause issues. So you have to think about that, but you can't leave it unequal shares. And we'll talk more about that later. And bequest to charities and individuals. So we'll talk about that too. You can, in your will, you can also do that. So here's a question for everyone in the audience. I'm going to give you a couple minutes to think about it. Can you disinherit your spouse? Can you disinherit an adult child? You got several choices here. Yes, you can disinherit both. Yes or no, you can disinherit child, but not your spouse. No and yes, you can disinherit the spouse, but not your children. Or no to neither. So what do you think? What do you think your choices are? Can you disinherit your spouse or your adult child? There's 4 choices there. I'll give you a little time to think about it. Okay, Joanne's voted already in the Q&A. Good. All right. Well, it's kind of interesting. You can't disinherit your spouse. So that one's for sure no. You can't disinherit adult children. So those are the ones that you have. You're just talking about the family fights and the problems through the years. Or maybe you have a special needs child that is already on the state system. You know, maybe they don't want to, you don't want them to have those assets because it just would go to the state. I know there's different things about that. So you can't disinherit adult child. Your spouse, she can refuse the inheritance if she wants to, but that's not, she still can't be disinherited. So the answer is you can't disinherit your spouse, but you can disinherit your children. Well, number 2 on that list. Okay. All right, go back down here. Good. So it looks like we have some that said both. So some said no. So now you've got multiple answers up there in the Q&A that now, yes, Patty, these webinars are being recorded as we speak. And there's a link in the chat box as where you can watch them at a later time to, if you have questions. I've had people attend these workshops. We were traveling roadshow and I attended 4 times to listen to the same workshops. They're not always the same because I don't always tell the same stories. So you know, they're always different things, but you can attend them that way. Okay. All right. Function the will cannot do. It cannot distribute non-probate assets. So there's probate assets that are controlled by the will and non-probate assets. So title of your property, this determines if it's going to be probate or non-probate. So if you have joint tenancy, ownership, transfer on death, payable on death, transfer on death deeds, those abbreviations are all mean. Those proceed before they're not probate assets. They won't be distributed by the will because how they're titled is already going to make them go the way they're titled. Okay, so they're not part of your assets that are probate. Does not avoid probate, but it's a will does not avoid probate. It triggers probate. So the will is basically, if you have a will, it's going to be your assets, your estate's going to be probated. If you don't have a will, you have to have $75,000 or more of assets in Minnesota to require probate without a will, or you have to have real estate. If you have any real estate when you die, it's going to go through probate, even if you don't have a will or trust. Okay, so those are 2 things to think about. Simple will versus complex wills. A simple will or sweetheart will usually directs everything to the surviving spouse or the children if no spouse survives. So we call it I love you will sometimes too. Because I love you, I'm going to give everything I own to this mouse. When I die, she's going to do the same thing to me when she dies, if I die second. But most time, us guys die first. We have a shorter lifespan. We do crazy things. It names a guardian and or conservator for your minor children, which is something you want to think about when you're younger. Well, I don't need a will. Well, maybe you do. You know, maybe you know who you'd like to raise your kids, who you think's financially better to raise the monetary, protect their assets for the future, what ages they can get it, those kind of things you can talk about in your will. A complex will utilize to create a trust or a structure for estate planning purposes upon death. So sometimes a titled AB trust or a contingent trust will, there's lots of ways to title them, but this is how example of how it works. So ideally, husband and wife, we own half the assets equally. Okay. Suzanne would own half, Dave owns the other half. Okay. We own it each. Hopefully, there's enough assets in there when we die that my spouse, Suzanne, could survive without my wife. My name is actually Suzanne, so it's kind of funny. But my spouse is surviving me, and I die first. If she's got her own assets already and can live on those assets, she doesn't need my assets. So what happens is my assets go to a trust. H, you see on the H, the husband goes down the trust. It's probated because it went through my will first, the complex will, and then my assets are set up in a trust. My spouse gets the income off the trust, well, she's alive. But then when she dies, my assets and her assets will both go down the bottom in the line there and go to the children, get all the assets for both husband and wife. If I gave my assets to her, and I love you, Will, and we talked about the state levels last time. If you're not a farmer or a small business, everybody in Minnesota has a $3 million threshold before you have to start paying estate taxes. So ideally, my wife would have $3 million in assets, and I would have $3 million in assets, and then they wouldn't go to surviving spouse. If I had an I love you will, and she got my $3 million when I died first, what would she have for a size? She'd have a $6 million will, wouldn't she? So she'd be subject to Minnesota estate taxes. So the good idea here is that it goes to that trust. The thing about the trust, because it's in a trust, it's like an irrevocable trust to her. Those assets can't be used for her nursing home costs. So she would use up her $3 million. Well, she's alive and could pay for a nursing home for a long time at $3 million. But those assets will be passed on to the kids in the H husband's trust. So there's a positive things about that. And we'll talk about that some more a little bit later. The challenge of a will, it's a public letter to the judge. So my former cohort was Gary Hockfield. He was a very private person. He did not want people to know his business. So he had a trust. A trust doesn't go through probate, but a will does. And that will goes through the judge in the court system, and it says, what are your assets? How are they taken care of? And like I just told you earlier, if you're 75,000 or more in any assets, it has to go through probate in Minnesota. If you have any real estate in Minnesota, it's going to go through probate. So you have to think about that. It's going to be public. Upon the first spouse's death, the property is owned individually or as tenants in common. It's going to go through probate, her or his share. Okay, individually or tenants in common, not joint tenancy. Because if it's joint tenancy, it's going to write to surviving spouse, as the second line says. So that's how its title is really important in this transfer process too. Okay, so again, the reason it's going to get probated in Minnesota: 75,000 or more in assets, real estate, or you have a will. Those three things are going to take any of those three things are going to make your estate go through probate. Okay, requires multiple probates if you own property in more than one state. So if you have, my parents are both in South Dakota. We went through, they both passed here. Last one this January. They both had assets in South Dakota and Minnesota. So they had to do probate in both states because it had to go through both states. So it happens. It's just part of the process. Some rule does not protect the assets from lawsuits and other adverse actions. So again, that happens too. It's harvest season. There's tractors, combines going down the road. It's dark. I met some farm equipment with the tractor. I can see the tractor coming, but what's pulling behind it in the dark? You don't really know what's coming behind it. So you could have lots of issues when you're going down the road at night. You also have heirs contesting the will. There was a family in Nebraska, for example, we used a long time. They had two farming brothers, 6 children altogether, and mom and dad died without any estate plan, other than a will. And the other 4, all 6 kids hired a will or attorney to fight the will, because mom and dad obviously wanted the farming heirs to farm. They were 40 farming, but the other ones didn't think that was fair the way it was distributed. So you think about that. It does not include guidelines for the care if you become disabled or incapacitated. So sometimes as we age, we don't realize it, but we're becoming slower and slower. Our mind becomes slower and slower. We can do less things, and we might become incapacitated before we even know it. And a trust will allow that. You can have some guidelines in your trust. A will, no such thing is allowed in there for that. So that's something else to think about. Probate. So this process, how long does it take? Well, from the date of death, it takes 12 to 18 months, usually for probate. And the cost can be 2 to 3% of the estate value. They don't charge a percentage, but you'll be surprised how that'll come true. So there's a cost to the heirs as a percent of the estate when they die, roughly. Okay, and it's time consuming. There's attorney costs. There's a lot of paperwork to do. If you have your children do it, they have some stuff to take care of. Also, it's open to the public. So if I have a will, I'm going through probate. There are people that can go down to the courthouse and see, oh, my wife just got X amount of assets transferred to her because I'm no longer around. I might have to get friendly with her or something. It's just those things happen. So if you don't want to open to the public, you should have a trust. Okay, because that's not going to go through probate. So the cost for a will is after you die. A will may cause family fights when you die. So we always encourage communication when you die. So a question from Philip in the chat box, or the question Q&A, is, if you have a trust and are managing it, does the income from the real estate farmland count as under an income from the trust manager if the original owner is manager of the trust? Okay, so I think to answer your question, Philip, so you're managing, you have a trust and you're managing it. So that means when you're managing, I think you're the owner of the trust. You have a trust and you're managing it. If you're not the owner and you're the trustee or just a farm manager for that trust, that income is just income to you from the trust. You have to file that as earned income for managing that trust for your parents, which I think is what happens. If the parents are getting their income off that real estate and you get part of that for managing it, that's how I would take it. Okay, if the original owner is managing the trust, then there's no management fee because they're getting all the income off rental off that land when they're retired. So that management fee, which you're talking about, I think is when you're not the landowner, you're managing it for your parents or uncle or somebody else. You get a management fee for taking care of the rental agreements and those things. That would be ordinary income to whoever's managing it. If I'm the owner of the trust, though, I'm not going to charge a management fee. I'm going to keep that income as rental income because a management fee technically could be a wage, and you, as a management fee, you could subject to self-employment tax. Rental income is not going to be self-employment tax. So again, there's some different issues around there. So hopefully I answered your question. Okay, so I'm going to close that out. All right, so the letter's open to the public, and you also have to, though, like we use attorneys, so attorneys will do this, but they have to send a letter to the Minnesota Department of Human Services. That is in case you haven't paid all your bills in nursing home. So husband and wife own that farm together, and that's their last assets of farmland. And father went into the nursing home first, and he stayed in there for a long time, used up all his half of the assets. He was broke, had less than $3,000 of assets, but he did own that land, and it didn't require to sell it because mom owned the other half, so she didn't force a sale. Human Services is building up an IOU. They're filing a lien on the property for what they didn't get paid from you or your spouse. So that'll clear that up, and then something have to be done when the second spouse dies. There'll be that IOU will still show up on the place. Okay, so that's what'll happen there. What is a trust? Well, trust is another tool in your farm transfer plan, is a means of holding those and managing your assets in the farm. Okay, trust generally consists of 4 parts. A trustee, yourself as a grantor of the trust, so it's usually a revocable trust, and you control it. So you're the trustee while you're alive. You can oftentimes name a successor trustee in there too. If you do die, it already has that done in the will. They won't become a successor until you die, but they can handle resolving your trust and carrying out your wishes of the trust. Cash, personal property, land are the property that's included in the trust. That's called funding the trust. You have to fund that trust by putting assets into that trust. However you name the trust, you have to put those assets into the trust. You rename the land to that trust name. You rename your card title, your checking accounts, different things. You put them in the trust. Okay. The beneficiary is going to be used to yourself as a revocable trust. So that's what's going to happen. And the instructions and guidelines for governing the trust assets are in that. You can have instructions, and it's really, really detailed. You can do a lot of things in the trust that you can't do in a will because it's going to carry on beyond your death. It can carry on. Minnesota, it's like 91 years from your youngest heir when you die. South Dakota, you can set up a trust out there, even for Minnesota property, and it'll go on forever. So there's things to think about where you set it up. It's established while you're alive, so you can change it. It's a living document. You're in charge. You have the assets. You can change those assets. You can sell the assets from land to stocks. You can sell the stocks and buy land. You can do lots of different things because you're in charge. Those assets are in the trust, but it's revocable. And you're the trustee, so you can control those assets. So it's a living document while you're alive, and it can still stay on beyond your death. Okay, there's a timeline that if you have Minnesota trust and there's a South Dakota trust, there's different rules how long it can last. Okay, so but you do it while you're alive. So the bad news about a trust is if you're doing it while you're alive, you're paying the fee up front. With probate, you're paying the fee after you die. With a trust, you're paying the fee up front, basically. It's going to possibly reduce estate costs because you know what they are right now. Whatever the attorney charges to set up a trust, and I've heard $10,000. I've heard 7, 6, whatever. There's a lot of numbers out there. Whoever you go see, it can. But once that's the cost, and the trustee, whoever takes over for your assets after you die, can transfer the trust however you want it, and it's going to be done with very little fees. Okay. They're not to be a probate process, so again, it doesn't have to go through the court system. It's done privately. And the only way you can really choose that is you have a pour over will as part of the trust. You want to make sure you also have a pour over will, not a regular will, but a pour over will. It sees everything out there. You've gone along. All of a sudden, I bought this nice new pickup before I died. Oh, I forgot to put the title of that in the trust. And unfortunately, pickups cost more than $75,000 today if you get a really fancy one. So that one asset didn't get put in the trust without a pour over will. I titled my name before I died. But if I have a pour over will, all my assets when I die will be poured back into the trust. Okay, so that's really key. If I don't have a pour over will, I could have probate on those assets that are outside the trust. And some people do that. Some people have a trust just for these assets, and they have these assets over here that are going to be probated because they want this stuff to go through a trust. They want, maybe this is all the land that goes through the, and this is the other stuff over here they want to use while they're alive and just not have it in the trust for whatever reason. It's a private document, so it's not public. And again, I talked about revocable, means it's changeable. So if you most of the time you set up a trust today, it's going to be revocable, where you have control of the assets while you're alive. You can change the rules, you can change what you have in there. And because you have control, the key factor revocable is get the stepped up basis when you die. That's a real positive. Irrevocable is not changeable. So if I set them up, usually with irrevocable trust, I might get the income, but I have no control. Whoever's going to get it when I die gets it. I'm not in charge of it. I can't change any rules. I set it up. I can still get the income while I'm alive. Somebody else is a trustee. So both, when you ever set up trust, you are gifting assets to the trust. So with a gift goes your basis. So when I have an irrevocable trust, the basis is going to be whatever it was I set in there for my heirs. When I have a revocable trust, because I control it during my lifetime until my day of death, it's going to get a stepped up basis, the fair market value of date of death. So my heirs get it basically a step value to the market when I die. That's the positive revocable.
Dave, before you go on, will you talk a little bit more? There's a question in the chat about pourable wills, and will you explain more about that?
Okay.
Pourable will.
A pour over will is just something, another document you do with your trust. So you establish your trust document. You're gonna fund it by turning the title of your land in there. You're gonna put the card title in there. You're gonna put the checking account title in there. Everything's gonna go into that trust by whatever I set the trust name up. But what if I forgot to put these stocks over here that I had invested? Aunt Harriet gave me some stocks 30 years ago. I forgot all about them. In this one account, they're in my safe deposit box. They're still in my name. If I have assets outside the trust that didn't get funded in the trust's name, they would get taxed, or they go through probate in my name when I died, if they're up to 75,000 or more, those stocks even. But when you do a trust, you also should do a pour over will. And that's just another document that goes along with your trust that says, does Dave Bow have any assets that I didn't have named in it? If I have Dave Bow Trust, and that stock certificate was not named in the trust, it's worth $100,000. It was named in Dave Bow. That pickup I just bought was named in Dave Bow. It was worth $75,000. So I got $175,000 of assets that I'm going to pay probate on. But because I have a pour over will, those assets, anything outside that wasn't titled in my trust, are going to be poured into the trust. That's the purpose of the pour over will. So if anything I forgot or anything I didn't do, I show that pour over will document, and then whatever those documents, those assets are, get transferred back into the trust. So then they're all included in the trust, and that's a positive thing. Okay. And because of the pour over will, it still goes through, it doesn't go through probate, but it gets stepped up basis because I still control those assets because it was will when I died, but now they're all part of the trust. Okay. So then I don't have to go through probate, don't do that probate process. That's how I tell you the answer for that. Okay. Yeah. So hopefully that answers your question.
And Dave, there's a couple more comments or questions in the chat.
Good.
We know that you dream, sleep, and all this. So yeah, when you get excited, if someone's asking you to speak slower.
I'm a fast talker. Yeah, I have Mountain Dew here too to keep me going fast.
Oh my gosh. Okay, and then there's another question too about
we're going to talk about transfer on death deeds as a non-probate asset later. We'll talk about how the title really controls how things are transferred. We're going to get there a little bit later. Okay, so we'll just keep that in mind. If we don't answer it, we'll talk more about it later. Okay. All right. So revocable trusts, they're a living document. Like I said, they're live where you can control them, you can change them. The grantor places the assets into the trust. Is called funding your trust. So you've got these assets. You have to change the title of your land to the trust name. You have to change the title of your checking account to the trust name. You have to change the title of your vehicles to the trust name. That way everything goes in there. Okay. Typically you name yourself as a trustee and beneficiary, and you have lots of control. So while you're alive, you can do whatever you want with those assets. You control them, therefore it gets stepped up basis. There's no income tax consequences when you put them into the trust. Those are still your assets. You're still going to have to function like your regular, if you're a partnership, individual, however you file your taxes aren't going to change. The exception in a trust is the pre-tax retirement accounts. The government will not let you get away from paying those taxes. So there are some tax consequences if you put your pre-tax retirement accounts, your regular IRAs, your 401ks, your SEP accounts, those things you haven't paid taxes on yet, they're pre-tax dollars, go in there. The IRS wants their money. So there is some taxes going to be consequences when you put those assets into your trust. Okay. They're not going to avoid taxes, but it's income tax when you die. Okay. The assets are included in your estate, your whole estate. So you list all your estate assets when you die, and they're upon your death, they get a stepped up basis to the fair market value on the date of death. So whatever we would encourage you to have everything appraised. Once you have it appraised, that's the fair market value on date of death. Okay, and that's a really good thing to do. If you have a whole long list of machinery, which farmers have millions of dollars sometimes now of machinery, go get an appraisal of all everything on there. So you have proof for down the road what the basis is on all those assets. With a revocable living trust, that's the RLT, you can add, remove, sell, gift, or trade any of the assets in there. So it's a living document. They can come in and out because you're in control. Another key factor of the trust, it enables you to do disability planning and allowing instructions for my future care. So I can put in there, do I want to be put on life support? Yes or no? I have a friend of mine, she's a minister, and she's not going to go on life support, period. She's not going to go on IV, period. That's what her wishes are. And so we'll see what happens. But right now, that's her wishes. So you can do all those instructions in a trust that you don't have to, but your trustees, your family and friends will follow these rules. So living trust, okay? You can put in there, you know, if I become incapacitated or not functional, how do I know? There's guidelines like you can have those rules in there to be take who you want to be cared by, all kinds of things. And it's really hard if you don't have that in there, because then you have to go to court to prove they're disabled. You know, you have to go to court to prove that your elder, who you respected and honored all your life, is not with us anymore in mental capacity. So it's not very much fun. So it's much easier if you have instruction that says, oh, you have to go see it's my primary doctor and somebody else, and if they say I'm incapacitated, it's that simple. That's what my will or my trust would have, those instructions. All kinds of things you can do with it. Okay. I talked about the pour of a will. It ensures that all your assets, old, newly acquired, are included in the trust. So that's again just pour. The assets in the pour of a will are subject to probate. So it doesn't avoid probate. So that again, most time, hopefully it's not going to be over 75,000, but you forgot. That's what they're saying there. So, and the trust assets are subject to estate taxes. So when you're figuring out all your estate, because you controlled it when you died, again, if you're a farmer, you can have that land in homestead or property when you die, and you farmed it, you know, it was 3 years before your death. You can get some exclusion. We talked about that for small business or farmland property. You can get that on top of that 3 million for everybody. So you have $5 million exclusion. Okay. So, but that trust is still going to be included in the value of that whole land. So if you have over $5 million, including your homestead land, you're going to have to pay some Minnesota state taxes. Federally, it's 12.92 million right now. It's inflation adjusted. So again, that's what it is today, individually. Your trust must be funded. I've talked about this a couple times, trying to give you that point that you have to fund your trust. So if your checking account didn't change, it's still a Sally Jones checking account. That's how it was before. Set up your trust. You didn't change the checking account, it's going to be probated. It's outside your trust. You might put in your trust with a pour of a will, but right now it's outside your trust. Okay. But if you go to the bank and say Sally Jones Living Trust is the new name of my checking account, now it's in my trust. I funded my trust with my checking account. Whatever my checking account is going to be part of the trust. Okay. So you have to fund the trust. Same with your title of your land. You'll see a lot of different names in the trust in your plat books now because they're funding them in the trust name. You'll see a lot of different abbreviations, names and stuff out there in the documents. The advantages of it are, the question from Ralph is, so even if you have a portable will under my trust, if you have over 75,000 of assets, Ralph, they would get probated. If you have real estate outside your trust, it would get probated regardless, even with a portable will. How do you add accounts to revocable trust? You just go and name them the trust name. That's how you add accounts. So like even your investment, your stockbroker, you could change that account to the name of the trust, to the checking account. You have the same thing with your stockbrokers accounts. You'd have them transfer that your trust name, your land, your titles, all those things should be. I'm going to go back up here and show you again. I'm going to go back one slide. Just like Sally here, we've got to change everything we own. We have to change. This is the name of the trust right here, these 4 words. So we're going to change our assets to that title. When we do that, that's funding the trust. Okay. We've transferred the name of the assets from my individual name to the trust name. It's called a gift. There's no taxes due. It's just gifting it, transferring those assets to the trust. So it's not anything more than just changing the title. Okay. Again, if most time it bypasses the probate process. Again, if you had some big forget-me's out there, it would cause a probate a little bit on whatever you forgot. It allows you flexibility and choices while you continue to own the assets while you're alive. So you might find out, my goal is to fast family farm onto my family. And I find out none of my kids really care that much and the grandkids don't care that much. What am I doing? Is that the right way I want to do it? Or do I have other ideas? Do I want to do some gifting now? And if I gift it to them, my basis goes to the gift, and guess what happens? They might not want to sell it if they pay. My basis is $1,000 and they get 10,000 an acre, or that might be a real hindrance to them selling that farmland someday. So that might be another strategy I use. There's lots of ways to do in this process. Trusts allow you to do disability planning in the process. It allows you to leave your loved ones in inheritance, protected from a divorce, liens, lawsuits, etc. So again, you can have bloodline language in your trust. There's outlaws and in-laws. You know what an outlaw is somebody who's married and outside the family bloodline. So they're outlaws. I'm an outlaw of my wife's family. So if you get along with the outlaws, then you want to include them, but you might not want to include them either. So it stays in the family bloodline. So you can do that in your trust. You can do that in your will, but your will is still probably going to have to figure out how they're going to share with the others. So I would encourage you to think about that and set up protections. Liens, with divorce, if you only have it to your bloodline, a divorce could hurt your assets. The spouse gets divorced and your child might have to give up some of your farmland. That's not what you want to see happen down the road. So again, your trust can go on beyond your death and protect it from a divorce of one of your heirs. So you can train those, you can still control those assets when you're alive, which is really a positive thing. And you can even reach beyond the grave. Trust allows you to do some of that too. The challenges, the cost is pretty high, likely higher than the will. A lot different. Like I just said, you can get a will done for less than $1,000 or around that, depending on what you do. And that trust is going to be probably at a zero behind that, for $10,000. So you pay a lot of money up front, but that means your heirs won't have to pay it at the end when you die. They'll have to pay the attorneys. So it's up to you. The trust is a living, working document. It may require updating. So if you're the trustee, a lot of the attorneys will have annual meetings, annual updates. There's probably a little fee for that too, but they'll make sure that you funded your trust. If you did this change, is it in there? They can check out that all you kept your assets in the trust. It still does what you want it to do. If it's not funded, it's just a stack of papers. My coworker talked about an attorney that did a lot of trusts and didn't fund them. You got to make sure you do the next. I'll take care of that. I'll transfer the titles of all these assets. I'll make sure it's funded. Well, do I have the time and willingness to do it? Or should I turn it all to make sure the attorney does it for me and make sure it gets funded? You pay a little money, but again, everything's transferred correctly. Okay. It's still part of your estate. So you get stepped up basis. You can register with the county assessor for the homestead designation. So again, even though I changed it from Sally Jones Living Trust, it's still Sally Jones Farm. She was still a farmer before she died. It's still going to stay a farm. It's still going to be eligible for homestead. It just got changed in title for the trust. You got funded the trust. So it's not going to hurt your homestead. Time is often less than a will because basically the trustee can take care of everything when you die after your successor trustee. The cost may be less than 1% of the estate value. It's a private process, so it's not through the courts. It's possible for the trustee to administer and close trust without any assistance from the attorney. Isn't that something to think about? You have this trust set up, and I know people have done this without going to see the attorney and close out the trust. So that's a private, free process that was done. So it's something to think about, but you still might want to include the attorney and make sure it's done correctly. We talked about irrevocable trusts, living trusts. They're non-changeable. So what's positive about them? They may reduce the estate cost because the assets are treated as a gift. They're not part of your estate anymore. The bad news, even with there's no set of basis at death with an irrevocable trust because you're not in control of them when you die. You may get the income, but somebody else is a trustee, somebody else control of it. And if the grantor is a trustee or the beneficiary of the irrevocable trust, it's not an irrevocable trust. It's got to be. If I set it up and the grantor, I'm not going to get it back when I die. It's not, or even when I'm alive, it's not going to be control. I don't have any control of it. I may get the income off while I'm alive, and when I die, it's going to go to whoever shows in the irrevocable trust. Okay. The bad news of that though, no stepped up basis. So again, it's kind of a challenge to see if you need that or not. Some people do that to try to lower their estate to get under the threshold, but right now, currently, our estate exemption levels are pretty high. So medical assistance is MA. IT is irrevocable trust, so abbreviations. So if you did establish an irrevocable trust prior to July 1st of 2005, it is protected from medical assistance. Okay, and here's how it goes. Mom is the grantor. She placed the land into an irrevocable trust. Daughter is trustee of the irrevocable trust. Mom gets the land rent while she's alive, but she can't change the provision of the irrevocable trust while she's alive. It's already transferred to daughter when she dies, and she gets the income of rent while she's alive. The land rent is countable as an asset when applying for medical assistance. The land is not an asset, but it had to be established before 2005. If you do one today, it's not going to avoid medical assistance. It's going to help you with the state taxes, but it's not going to help you with medical assistance. So if I put everything I had in this irrevocable trust and I went on $3,000 less than medical assistance, it's I established that irrevocable trust today or after 2005, it's going to be subject to the land or my assets being taxed or put a lien on by whoever I got medical assistance from, nursing home, whatever. So that's the problem with that. I think did I repeat the slide here? Oh, and then here it talks about on or after. And then it talks about those assets are going to be considered countable assets. That's all it says. I did that myself, but it's the same slide, just saying after July 2005, it's going to be a medical assistant asset, period. Minnesota, there's no protection anymore for this trust like it used to be. Charitable remainder trust, okay, is an irrevocable trust. So you might decide today that I want to give my church, my school, my high school, some assets. I want to do it all my life, so I'm happy and feeling good about it and do it while I'm alive. So I can set up a charitable remainder trust. You transfer the asset while you're alive to whatever that trust, that title of that charitable remainder trust is. So really, I'll use the church, for example. I gave the land to the church. I titled over the church and the trust, but yet I can retain the income stream while I'm alive, or my spouse's life. So we get the income off of it. So I reduced the size of my estate by that gift, whatever that amount is. Those assets are not going to be included in my estate. I also get a credit. So I gave, let's say, $100,000 of land away. I'll get a credit on my income tax for that gift of $100,000 if I can use it on my taxes. So there's a positive there as well. So there's a lot of ways you can do this, and again, you get the benefit of feeling appreciated with a gift while you're alive by doing a charitable remainder trust. FSA requirements for trusts. FSA does not require a copy of your revolving living trust, revocable living trust, unless the trust receives a payment or is a recon of the farm. So you're restructuring the farm and reconstituting who's involved. So if you just change the trust from Dave Bow Farms to Dave Bow's Trust, it's not going to really affect anything with the farm. If I do an irrevocable trust, though, and they are a separate entity, they will need a separate tax ID number. So when you set up a trust, you can establish get a tax ID number, and then you'll have to pay that entity separate entity throughout the process. You set up a trust and you have income coming from that trust, you get to pay income tax on the trust documents. And usually trusts are taxed at a higher rate than personal. So you have to think about that too. But again, work with your FSA locally when establishing a trust or doing any structural changes to your farm. All right. Polling question. Do you have an up-to-date will or trust? Yes or no, or sort of. So, when we got married, we set up a trust or we set up a will. We didn't have any kids. It's just husband and wife. I have a will, sort of. Is it current to what I want today? Probably not. So it's not up to date, is it really? I've got 3 adult kids now. 2 of them are married. A lot of things to think about in that process. So again, the question to you is, do you have those things? How you feel yourself? All right. Good. So Jeremy says he does. Good.
That sounds good. So now I'm going to get to present on the next section of slides. Dave, okay, great. And then I'll share my screen. Just a second here while I get it all in place. So, Dave, you were talking about wills and trusts. I saw that someone had their hand raised. We'll take questions at the end. Would that be okay? We'll kind of save your question till the end, and we'll go with questions at the end. And we'll even be able to unmute at that time. So we'll have a little bit of Q&A time. So like Dave was saying, I'm Suzanne Henricks. I'm a member of the Ag Business Management team. Same with Nathan and Dave. And we were noticing too that, Nathan is on his vacation. So we decided that we really shouldn't make him have to present from wherever he is in another state. So we're going with me on this one, and I have a few slides. I'm just, Dave, having a couple problems with my screen, so it'll be just a second here while I look up my items. Okay, so I think, are you able to see my PowerPoint deck, Dave?
Yes.
Okay, wonderful. So you're seeing that. So my portion is really going to be on more business structures, and as you think about your farm transition and what you want and ways you want to teach the next generation about your farm management and systems on your farm, it's important to think about those business structures. Maybe you already have one set up, or maybe you're looking at, what it should be set up. So Dave presented on wills and trusts, and now we're kind of moving into that business structure of how your farm should be structured. So we're going to review the types of business structures on the screen here, and we'll kind of talk a little bit about liability protection that each of those business structures gives you. Maybe it doesn't give you any liability protection. So we won't go into a ton of depth. We have a coworker, Rob Holcomb, who does a 3-hour presentation just on business structures. So we can get you that information as well in case you're interested specifically in this. He goes into the pros and cons of each one. So the first type of ownership, this type is sole proprietorship. So think about how you file your taxes. What's your tax filing status? Do you just file your taxes as yourself, or you and your spouse? Well, that's a sole proprietor. That's a sole proprietorship. So this is the easiest way to start farming. You just start farming and you go. It's, you know, a lot of ways the simplest, because there's a lack of that business structure with this business entity, which makes it really flexible. So when thinking about farm transitions, it's a good idea to plan for the business structure that you want that will also allow a younger generation to kind of dip their toe in. Maybe they want to test the waters and see what is farming like. Are they going to like farming and being a part of your farm? Well, they can keep their day job with a sole proprietorship, and then they can start working maybe for a wage after their 40 hours or whatever they're doing for their other job. So it's a good structure for the older generation too. Maybe you would want to give some responsibility to a younger generation, but then still keep your management of the farm intact. This sole proprietor business structure gives you that flexibility. So I'll just say that there is a lack, though, of protection, liability protection with the sole proprietor business structure, because really it is just you and your farm as the business structure. So let's say that your niece is starting to work with you on the farm. She has an interest in possibly in the future working with you in a farm transition, and she takes the grain truck out on the highway and gets into an accident. Maybe someone's seriously hurt or maybe even killed. That doesn't, the sole proprietor structure doesn't give you any protection against an insurance company who might come after you, your niece, your farm. So there's really a lack of personal liability protection with the sole proprietorship. So the next part, though, is partnerships. And so there's different kinds. There's 3 kinds of partnerships, and general partnership, and then 2 partnerships that have a little bit more liability protection. So we'll go into these. The general partnership is a lot like the sole proprietorship, except it's partners. So it does detail out who is in the partnership. This business structure allows for the new generation to enter into the farming operation and formalizes that partnership. So in a general partnership, each partner shares equally in the rights and responsibilities of the partnership, and the partnership, each person is sharing in the debts and obligations of the business. So it's similar to that sole proprietorship, like I said, but because it doesn't have any personal liability protections. So this general partnership, you know, if in the example that we had before, if there is an accident and someone sues the farm, it still is personal assets that would be liable, such as checking accounts or other investments or even equipment that could be at risk in the case of the settlement of a lawsuit. So Minnesota doesn't require partnership agreements, but we suggest, you know, you do this. It doesn't require it to be filed, let me say it that way, but it's really good to talk about what you have as who are the owners, how you operate, what are your processes, and how you would talk about that as you think about adding a next generation to the farm. Maybe it's a child or a niece or nephew. So these are things to think about as you kind of look at bringing in the next generation. The next partnership is the limited liability partnership. So this does have a formalized legal structure. It requires a bit of paperwork in Minnesota to be recognized as a limited liability partnership. It's just a simple certificate that you have to file with the Minnesota Secretary of State. It needs to be renewed each year. That shows that you're still in business. So it's simple and the paperwork just states who the partners are and what type of business you're conducting. So it's just that certificate that you need to file. This limited liability partnership is easy to start. It's easy to change. And as a new generation or maybe a partner gets added. So it's a possible step in your farm transition if you are adding your son or your daughter, and if they've determined that farming is right. So maybe you've kind of dabbled in, they've been working on the farm with you, and they're ready to kind of take on some responsibility. And this would be a good one to have in place. Looking at the personal protection liability side of it, the limited liability partnership does have protections for partners against claims against the farming business. So in the scenario where your niece is maybe coming into the business, you have developed a limited liability partnership. She takes the grain truck to the elevator, and on the way she gets into a serious accident. Your personal assets would be protected. They are protected with the limited liability partnership. The liability for the insurance claim would only be with the partnership and not you or your personal checking account or any other personal property. So this business structure might be right for you. But there's also the limited liability company. And the limited liability company is what the limited liability partnership has in the way of protections for liabilities. The owners can still run the business how you want it. The limited liability company can be one person or multiple people. So that's an interesting thing, that you, as your own farm, just you can create a limited liability company, but you can also create that with partners too. So the only difference between the limited liability partnership and the limited liability company is that when you're filing that certificate with the Secretary of State, with the limited liability company, you need to file a few articles of incorporation, like how you're going to be organized, how often you're going to meet, some of your business processes. So there's some questions that they'll want answered with that. So with the limited liability company, these are things that you should be thinking about anyway if you're going into business with a partner, such as a son or a daughter, or maybe a niece or a nephew or someone. So for tax purposes, it's a pass-through. So a limited liability company, it means that there's no double taxation, which we'll get into here a little bit with corporations. So for tax purposes, there's no double taxation. It's just you and your taxes. Limited liability companies have become pretty popular because they really offer you the same personal liability protection as the limited liability partnership. And it also has some of the benefits of the corporation in that organizational pieces. So we'll talk a little bit more about benefits in a little bit. So another type of business structure is the corporation. And a corporation is a very distinct entity. So I want to just make sure that you recognize that, and maybe some of you already have corporations. So the business structure is very different from the owners. So I have a farmer friend who owns a beef cattle farm near here. He also owns a manufacturing company that makes a product for distribution. And that corporation is very separate from him. He might be an owner of this corporation, but it's a separate entity. That's how it would be for your farm too. There are two different types of corporations, the S Corp and the C Corp. The S Corp has the pass-through that I mentioned earlier for tax purposes as well. So let's focus on the C Corporation. The C Corporation is taxed as its own entity. So it has a business tax. It also has individuals who are members of that corporation have taxes that they pay on their own income. So that's what we meant by double taxation. So that's what it means to be a C corporation. Double taxation could be a negative, that the company is getting taxed, but then also individuals who are owners in that company are getting taxed on their own income too. So this could be some protection though for you as well. There's some pros and cons of this. The corporation can own and operate assets. So the assets of the farm in a corporation situation, like the livestock, machinery, they can all be owned by the corporation. We don't recommend that you put land in a corporation, but machinery, livestock, and other things can be an asset of the corporation. So getting into the corporation, when you're establishing it, it can be a tax-free event just to establish it. But corporations have been popular now for a few decades, 30 to 40 years, and it's definitely not tax-free to get out. So if you're dissolving a corporation, it's kind of complicated. So you want to kind of look at all sides of this when you're establishing a corporation. C corporations were common, like say 40 years ago, and people are just finding that they're expensive to dissolve or get out. In the case of a death, so when the early members of the corporation pass away, it can be expensive for the generation that is taking it on as well. So there's just some things that you'd want to talk about with your attorney about a C corporation, but it's a viable business entity, and I just wanted to make sure that you knew about it. I'd say the benefits that we see with corporations, it offers continuation and allows for you, the next generation and others, to enter the corporation and go from the corporation. So it's a separate entity. It offers, longevity so that you can be planning for your generation and the next. And individuals can own assets outside of the corporation. And if mom and dad want to own the cows, if you put it into an LLC, so a limited liability company, or an S corp or a C corp, the incoming generation can gain ownership over a few years' time in the corporation. They don't necessarily need to purchase the cows right off the bat. So it could be that that's an ownership tool because it's owned with the corporation. You could also have an incoming generation purchase into the business. So they would purchase percentages over time, which would be a benefit, so that that incoming generation doesn't have to bite off a big chunk at one time. They can maybe invest, say, 5% each year so that they are a 5% owner. Then the next year they'd be a 10% owner. So those are ways you can do that with all of these LLCs, S corp, and C corp. So corporations for liability protection, this is really where you get some benefits as well. Liability protection is a key piece of corporations because they're they're separate from your personal assets. So insurance would be something that a person takes out. It's also something that a corporation invests in. So you would have different insurance investments. And if you're talking about like a catastrophic event that would threaten the assets of a farm, it's really where an S corp or a C corp are very strong in personal protection liability, because it is only assets that are involved with the corporation that would be affected in the case of, like, it would an accident or some sort of catastrophic event. There are unique operating tax deductions that corporations need to consider. So those are things that you also want to look into as you would establish or be thinking about a corporation. And like I said before, we don't recommend that you put land into ownership into the corporation. It's possible for a corporation to rent land. So like my family, we have a family farm. It's the Hanson Land Corporation rents the farmland to the company. So what about the corporation? What does it mean to be a corporation? So like I said, my family has this Hanson Land Corporation. If you want to be taxed as a corporation rather than a limited liability partnership or a limited liability company and receive the tax benefits and receive the personal liability protection that a corporation might be for you. So these business structures need to be registered with the Minnesota Secretary of State. However, when you're establishing a corporation, there's much more that you need to think about and provide. So an IRS or the corporation can be audited by the IRS. So you want to really set it up so that you have good mechanisms for record keeping and you keep separate records for that corporation. The corporation needs to have a separate checking account. Like you shouldn't purchase groceries with the corporation's checkbook. Keep the business accounts separate from your personal accounts. And then, businesses do get audited by the IRS. So if a corporation gets audited, they are going to be looking for things like improper expenses, such as groceries, flowing through that corporation's business account. So just think about making sure you keep business on one side and then personal on the other side. And one more thing, that corporations need to have regular meetings. And if you don't have minutes, then it's almost like you didn't have meetings. So make sure you have record keeping of even your minutes and keep those in a place, either a paper file or on your computer so that you can provide them.
Suzanne, there was one question in the chat box or quite
Thank you.
about LLCs. And I just looked quickly at the IRS classifications and it says it's treated as a separate entity from anonymous attendees. So you'd have to, I don't know, it can't really probably go on your personal Schedule F if you have a LLC out with part of the farm. If the whole farm is part of that, then it could go on a Schedule F if that's the entity you follow. So I just did a quick query and it said you'd have to treat it as a separate. And the other part, if you did a close corporation, I don't think you want that. So again, just a question on answering the question there.
Thank you very much. And like you're saying, an LLC is a good option for that. Okay. Okay, so I'm going to get into discounting assets that are placed into the entity. So we talked about farm assets a little bit ago, that they can be placed into a corporation, and then they're an asset of the corporation. It's possible that when assets are placed into the corporation, they can be discounted. So this is another attractive piece of corporation. Usually an asset is valued at the fair market value, like Dave was talking about earlier, when a farm transition happens. However, assets can be discounted when they're placed into the business entity. So we're talking really a fairly large discount. It could be between about 20 to 40% of a discount from fair market value. So that's a pretty large discount when you think about the cost of equipment nowadays. So there is value in this because it lowers the value of the entire estate and makes it a bit easier for a son or daughter or another person to buy into your corporation. So it could be more affordable for them to enter with this discounting of assets option. So this affects your basis for equipment and items. It lowers the basis for that discounted asset. So this could be a challenge because as basis gets stepped up upon death or with the transfer of that equipment, it would lower the basis if you discounted them. So keep that in mind too, that it affects your basis. Discounting does. The IRS doesn't hold any pros or cons in discounting of assets. They're neutral on it, but it's allowed. So you'd want to speak to your tax accountant and ask about, if you're creating a corporation, what discounting assets and how they might be able to strategize with you on lowering your estate. Okay, so the role of the entity, in your business transition, as you think of your farm transition, bringing a newer generation into the farm and teaching them your farm management and your decision-making process, it's good to think about these business structures, and maybe one fits you better than another. One of the big benefits of using an S or a C corporation or a limited liability company are that you don't have to deal with specific assets and transfer each of those assets. So let's say your nephew is looking to buy into your farm. With the S or C corporation, or even that limited liability company, he doesn't need to buy the farming operation, one bit at a time, or buy it all at a time. He doesn't have to buy just, one tractor in 1 year, and then other pieces of equipment, maybe the baler next year. He can purchase, like I said earlier, just that 1% or a 5% stake in the corporation. So that's something that's interesting too. So what does the Farm Service Agency say about this? Well, the Farm Bill says that payments from USDA that are paid through the FSA need to be paid to farmers who are actively engaged in farming. So this is something, if you're a member of one of these business entities, your payment, you need to just keep in mind that the USDA through FSA says your maximum that can be paid to you is $125,000. So let me explain it a little bit differently. So if you're a member of one of these business entities, that entity is limited to receive a total of no more than $125,000 in either direct or indirect payments from the USDA. So this is something that has continued on in the Farm Bill. So you're probably already aware of it, but if you're not, just keep that in mind too. One last thing we want to just, caution you on is that you should always really get to know the people that you might be going into a partnership with. If you are establishing a new partnership, let's say it's with your neighbor's son, someone that you maybe have known, but you don't know them every detail, keep in mind, do they have any things that are in their past that you should know about? Do you know their background? Maybe they have a wetland or other conservation violation that the FSA doesn't appreciate, or whatever it might be. Just wanted to say, just get to know people that you're going into partnership with. Most of the time it's going to be family, but wanted to say that. And then here's a graph that we have for you in the slide deck when you download it, or when we send it to you at the end of the series. You can check this out to kind of gauge what are your preferences for, outside investment or ease of entrance and exit for family members who might be coming or going, or just the structure. So this is a little graph that shows you how we think about them, if we're neutral or if things are good or maybe not as favorable. And then the last section that I'm going to cover today in our webinar is property ownership types. It's important to think about your ownership of land and who owns it, and the various types of ownership of property. So property ownership affects who signs paperwork and the future rights of all those who are involved. So let's talk a little bit about the common property ownership. So property ownership, the first type is sole ownership. It's just a single person, a divorced person, or maybe a widowed person who owns the property. It's possible for a person who is married to be a sole owner, but that's not very common because you'd have to write that into paperwork. But it's a simple way. Sole ownership is a simple way to own land because it's just you, yourself, and I. So in the case of the sole owner's death, then it would be up to that personal representative who's probating your will to pay off your debts and then distribute the assets to beneficiaries. So it's basically the same process without a will, but it would take a little bit longer, as Dave was mentioning, how long probate can take. So we encourage you, of course, to make a will or have things in a trust. If there's more than 2 or more people, tenancy in common is a common way to own property. You can have equal shares or you can have unequal shares. This is tenancy in common. This can be 2 people who are married, or they don't have to be married. 2 or more people can own property in tenants in common. So no matter if it's a husband and a wife, or maybe a brother and a sister, both owners as tenants in common need to be involved in, paperwork and all of the things that go along with ownership. But when there's a death, when one of the landowners is a tenant in common, so in this scenario, if one of the owners dies, it is dealt with through the estate, and the person probating the will deal with transferring that portion or that land. It's not automatic. It has to go through the will and the probate process. So that's tenants in common. So for example, if me and my brother own property as tenants in common, and he dies, his 50% goes through his estate, and a probate may be required depending on the size of his estate. And it would also go through his estate to determine who gets that portion. So it's not an automatic where the portion of the property goes in tenants in common. We just want to make sure that italic part at the bottom of the slide, we just want to mention too that sometimes your deed doesn't actually even say what kind of deed or ownership type it is. If it doesn't say it, in Minnesota, it's automatically a tenants in common. So if it doesn't say it, it's automatically this kind of ownership for property. So the next type is joint tenancy. So they're very similar in their language, but this one is joint tenancy. Joint tenancy is similar because property can be owned by 2 or more people. However, joint tenancy needs to be specified as the type of ownership. Otherwise, it defaults to tenancy in common. So if you want it to be joint tenancy, you need to state it. This type of ownership for property allows for rights of survivorship. So that might be attractive to you. So in the example of my brother and I owning land together, and let's say I die, my half, my 50% of the ownership would pass to my heirs automatically. So it's through the right of survivorship. And joint tenancy ownership, then this means that my brother would be now owning that land with my husband. So that's because of our sweetheart will. He would own that portion of the land. So joint tenancy avoids probate altogether. But remember, it does need to say it. And on this slide, it says a good example of what it should state in your language on the deed. So it should say joint tenants. Oh, go ahead.
I was looking confused, Suzanne. So
okay,
the simple thing is, if you and your brother have tenants in common, then your husband can get the land. However, you've got your will or trust. If you have joint tenants with the right of survivorship, then your brother would get your land because it
good point.
It goes right to him because you get joint tenants. So most time joint tenants with right of survivorship is usually a husband and wife where the surviving spouse gets the land. But if you want to go to your kids or your husband, then you want to make sure if you have with your brother, you want tenants in common. Okay.
And if you want, Dave, correct me if I'm wrong. So joint tenancy, if you want it to go to, let's say I want to designate my 50% to my sister.
It won't go to your sister because on joint tenancy, however, whoever's the other joint tenancy with you with right of survivorship means whoever outlives each other gets the land. So only way your sister would get it or your husband or your kids is if you have tenants in common, and then it goes to your will or your trust, however you decide for your assets. If it's joint tenancy with the right of survivorship, if you have 3 siblings and the last one alive gets it, is how it works. You know, like you might have 3 kids that have no kids. I know families that all 3 kids don't have kids. So it just keeps going down until the last surviving stander gets the whole farm. So
Thank you for clearing that up, because they are confusing, but you want to make sure that you have that survivorship piece if you want joint tenancy. Okay. And the one last thing we wanted to talk about in this section is life estate and remainder. So you can create a life estate. It's another type of property terminology, and we just want to explain it here because it's been on the books for a long time. Minnesota has recognized this life estate as a way to own property. So life estate is a type of joint ownership of property where the ownership is split between the present interest and the remainder interest. A life estate is like an individual's right to use the property and even receive income from it until their death. So this usually happens when the property is transferred to someone, but someone else retains the right to possess or even profit or control the property during their lifetime. So the person holding the life estate with the right to possess the property for their lifetime is called the life tenant. That's the person who holds the life estate. The person who is given ownership of the property in the life estate is called the remainder person. So it could be you gifting it. So example, and a common situation might be a parent might convey the property, the title to the property to maybe one or even more of their children, but they reserve the life estate in the deed. So that means that the parent retains the life estate in this gift to the children. They retain the right to use it and even profit from the property during their lifetime. So they would use it. They might live in the house. They might, you know, use the barn, things like that. They're going to be the life tenant who holds the life estate. The person who has been given the gift is the remainder person. In the case of all life estates, the life tenant, the person who's using it, does get to use it. They get to use it and control that property. So they would be managing that yard and the barn and the farm yard how they see fit. They also would be paying taxes and they'd be obligated, you know, to have insurance, things like that. So the life tenant also has exclusive rights. If they were to like rent out something on the farm, they could do that and they could get that income. So the remainder interest comes into play because the remainder person is the person who's given ownership in the property of the life estate. So that's the remainder part of this, the person who has been given that property. So for example, grandma and grandpa might convey ownership of their farmyard as a gift and maybe the 40 acres next to the farmyard. And maybe a grandchild is going to get it and they're going to be involved in farming. So it seems right that in the future, they're going to own that. So they will own it, but grandma and grandpa will be living there. So the grandchild is the remainder interest. They hold the ownership of the property, but grandma and grandpa will hold the life estate because they will be the life tenant on that space. You know, you work with your attorney or your tax accountant to put this in place. You also need to determine what the value of the gift is, because you can also have, it just needs to be calculated by an attorney or an accountant. When a life tenant dies, you only need to have the affidavit of survivorship and the official or certified copy of the death certificate, and then that's how you remove the life tenant from the deed. So it's pretty easy. No probate is required here. It's kind of confusing in its language, but it's a really good option for Minnesota. And there are some calculations. I had said that maybe go to your tax accountant or your attorney to figure it out. There are charts and calculations depending on what age you take out. Take it out that you might be able to, kind of have an idea of what percentage it is. So Dave, I don't know if you want to speak about this chart a little bit.
Yeah,
I'm
this
also going to
table-
turn it over to you for the next slide.
All right, this table basically just shows, say I went in the nursing home when I was 88. I had a life estate. Well, technically at 88, I still own 30% of the life estate. So that's what it means that, so the heirs already have 69%, but if I was on medical assistance and I went in the nursing home at 88, 30% of this value of this estate would still be subject to medical assistance. Unless, so that's what it means. That's what this table is used for. Figure out those assets that I set up the life estate with are still subject to medical assistance. Okay, if you want to go next slide then. All right, there's one more in there you want to talk about? Was there one between?
No,
Nope.
go ahead. If you want to just take it over, I'm going to pass it over to you at this point.
All right, so ownership of the contract. So this is where title, how you have it titled. If you have a contract deed, you've already done that. That's one way for sure. You get it passed on the next generation, a basis at whatever they paid for it. But you want to make sure you also have ownership by contract with these beneficiary designations on your insurance policies. If it's your insurance policy and it's in your name and it's going to come back to yourself with payout, you don't necessarily want that because that's going to get included in your estate. It's all going to be subject to estate taxes. So you want to make sure you have beneficiaries on your insurance accounts, on your annuities, on your investment plans, so that you don't have to have that problem. If correct, the assets pass it to the beneficiary, just how you have it set up. It's pretty simple. They just have to prove a death certificate, may have some requirements for those, whatever the business has, and you'll have those assets transferred to your heirs. Transferring to a trust, assets at death pass through the trust to the heirs. So if you have the assets in a trust, like she was just talking about all these trust rules and different things. Well, when you die, maybe the trust dies with you. In other words, the trust assets go to the heirs. It can end at your death too. And the successor trustees has to make sure those assets go the way your trust wants them to. Or it can go on forever, but you just have to make sure you have the trustee in control. It's still going to go to those heirs. They control the ownership of it now in the trust. Other designations, the pay on death, checking and saving the CDs. If you do that, it automatically goes to whatever you have listed there. The only thing you want to think about is, what about all your bills? What about the funeral expenses? What about the medical costs at the end? If you put pay on death to one of your kids who's been taking care of your finances, the other kids, it's that person's assets at your death. So you want to make sure you have other kids listed on there if you want to go to all the kids. But if you transfer right away, those kids have to agree on how they're going to pay for your costs. If that's your source of cash. Transfer on death, again, investment accounts. If your mom or dad or grandma and grandpa have investment accounts, they can make sure they're aware of how they set that up so they can have it transferred on death to those accounts. And you do it before you die. So you already know right away when you die, those assets, all these assets aren't going to go through probate. They're already under contract. They're not, if you have them going to somebody else besides yourself, they're not going to go into your estate. Okay, that's the good news. And a transfer on death deed is much more common. So you put on there right away a transfer on death deed, and you just take that document, you already had it, and you just take it and have it recorded. And after somebody dies, the death certificate, it goes to whoever you want, whoever you have on there at the death on the real estate. And life estate or contract for deed, we just talked about it. They're also you've already transferred the asset with life estate. You've transferred usually land to your heirs, grandkids, kids, whatever, and you get the income while you're alive. And they just say your life expectancy is, if we live to 90, well, you have very little left of the assets but that's how it works. And contract deed, same way. You've already at your death. It can either be a balloon payment or the contract can live beyond your death, depending on what your heirs want to do at that point as well. So those are what under contract just want me to talk about a little bit. Go ahead, Suzanne.
Dave, there's a question in the chat about just a comment that we were talking a little bit about nursing homes and medical assistance and Medicare. Can you talk a little bit more about that look back, or, you know, someone who's 88 might not be on Medicare or
There's a
medical
5-year look
assistance?
back. Okay, so if I was 88 years old and I had no assets anymore, you can have $3,000 of assets at the max to be subject to medical assistance. Medicare is totally different. Medical assistance is Medicaid, kind of, so to speak, you know, so you might not be able to pay the bill at nursing home yet with only $3,000 of assets. You know, it costs $10,000 a month or something right now. So the first month you go in there, you don't have to spend your $3,000 down. You can still keep that for incidentals, but you're going to have a $10,000 bill that you're not going to be able to pay at 88. And that's where the medical assistant comes into play. They're going to pay that $10,000 to nursing home. They're going to keep track of it. So if you live, average stay is 37 months, and we'll say $10,000 a month, we're looking at $37,000 that's going to be subject to the estate. And when you went in at 88, you still had whatever I said, 30% of it. So that 30% can come off whatever those assets were in the life estate. Follow. So that's what that means for the benefit or subject. But that's only if you took medical assistance, not Medicare. Medicare is just your health insurance stuff that you take. Everybody has to take when we turn 65. We have to buy Medicare. But Medicaid is kind of this, when you get down to no income, no assets, and then all of a sudden it kicks in. But again, the life estate is still going to have probably some income for you while you're alive. So that would make that cost. They would pay that all that medical assistance percentage. There's a percent you get to keep too, but most of it would go towards that cost nursing home too. So it wouldn't be $10,000 a month. But again, this chart just shows you what you would have if I had a $2 million assets of this land I gave away, which I could instead of a life estate. That's what would be left of it. So I'd have quite a bit of value left in my estate, life estate, that could be subject to paying the, if I was on aid for couldn't pay my bill at the nursing home. Okay.
And you said that look back window is 5 years, right?
Yeah.
Okay. There's also another question. Is there a difference in tax and MA consequences between using a life estate or payable or death?
Okay. Well, if you have a transfer on death deed,
Transfer death.
we'll go with that first. That transfers right away at death. But if that was your only asset, it would still be subject to that lien, because when you died, you still owned that asset. So the IRS would say, did you own anything when you died? And the answer is you owned that real estate. And even though it passed to your heirs, somehow it's still be liable. Life estate, they're going to file a lien on both properties, both ways, no matter what they do. Because when you were alive, you built up a $37,000 bill with medical assistance. That's either going to come against the life estate because you're going to have that much in your assets of remainder interest, or of life estate. And then also on the transfer on death deed, it transfers your death to your heirs, whoever you want it to, but there's still going to be those medical expenses that are going to be paid somehow. And the IRS or Minnesota Department is still going to go after that land if it was transferred, if whoever had the asset dies. So again, transfer on death is a great tool because it doesn't go through probate. If you talk about probate, it goes right to the heirs with no subject to state taxes and no probate issues. But it's still, if you have medical assistance, it's a different story. They're going to want their money if you have assets when you die. They're going to get someplace. And so there's no difference between a life estate or, if a certain amount was not very much in there, that's would be a limiting factor in the life estate. Whereas a transfer on death deed, the whole asset's sitting there at your ownership on the day of death. So it's still, somebody's going to pay the medical assistance if you have assets when you're alive. Let's put it that way. And the life estate would check some of it, maybe if it got down to where it was very little left of it when you died. Okay. Hopefully that answers your question.